In the last 18 months, 10 major changes to gun laws have reshaped the Second Amendment landscape in America. Some are massive wins for gun owners, some are devastating losses, and most gun owners have no idea half of these changes even happened. We're talking about federal laws that were enforced for decades suddenly being thrown out. We're talking about taxes that existed since 1934 being eliminated by Congress. We're talking about Supreme Court decisions that will affect every single gun owner in this country. But here's the problem. These changes happened at different times. Some were court decisions. Some were executive actions. Some were congressional laws. Unless you've been tracking every single development, you probably missed at least half of them. So let me break down all 10 changes, what they mean for you right now, and what you need to do to stay legal and protect your rights. Quick question before we dive in. Are you subscribed yet? Because what I'm about to reveal is a complete timeline of every major gun law change from 2024 through early 2026. We're talking about changes that affect concealed carry, NFA items, ATF enforcement, Supreme Court precedent, and more. Hit that subscribe button right now, because if you miss even one of these, you could be breaking the law without realizing it or missing out on rights you didn't know you had. Subscribe. Turn on notifications. Let's get into it. All right, change number 1. The pistol brace rule was vacated and is now completely dead. Here's what happened. In January 2023, the ATF under the Biden administration issued a final rule classifying pistols with stabilizing braces as short-barreled rifles under the National Firearms Act. Overnight, millions of legally owned AR pistols and AK pistols became NFA items. You had to register them, pay a $200 tax stamp, or face felony charges. The ATF gave gun owners until May 31st, 2023 to comply. After that, possession of an unregistered braced pistol was a federal crime punishable by up to 10 years in prison. Gun rights groups immediately sued. The NRA filed lawsuits. Firearms Policy Coalition filed FRAC versus ATF. Gun Owners of America filed multiple challenges. These cases argued the ATF exceeded its statutory authority. The Gun Control Act and National Firearms Act define what a rifle is. A rifle is designed to be fired from the shoulder. A pistol brace doesn't redesign a pistol into a rifle. It's an accessory. The ATF can't redefine millions of firearms through administrative rulemaking. The courts agreed. In 2024, the case Mock v. Garland resulted in the rule being vacated. The Eighth Circuit in FRAC v. ATF ruled the pistol brace rule was unenforceable. After losing in court, the ATF conceded. They stopped defending the rule. The rule is dead. As of now, pistol braces are completely legal under federal law. You do not need to register your braced pistol. You do not need to remove the brace. You do not need to pay a tax stamp. This is a huge victory. But remember, the ATF could try again under a future administration. So don't throw away your documentation. Keep records showing when you acquired your brace and your pistol. Change number 2. On July 4th, 2025, President Trump signed H.R. 1 into law. This law eliminated the $200 tax stamp on suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons under the National Firearms Act. The $200 NFA tax that has existed since 1934 is gone for these items. Effective January 1st, 2026, you can buy a suppressor without paying the $200 tax. You can build a short-barreled rifle without paying the tax. You can buy a short-barreled shotgun without paying the tax. This is the biggest change to the NFA in 92 years. But here's what you need to understand. The tax is eliminated, but registration is not. You still have to fill out ATF Form 4 or Form 1. You still have to submit fingerprints. You still have to wait for ATF approval. You still have to pass a background check. The only thing that's gone is the $200 fee. So if you've been thinking about buying a suppressor, now is the time. Starting January the 1st, 2026, you save $200. If you want 5 suppressors, you save $1,000. If you want to build 3 SBRs, you save $600. Over a lifetime of gun ownership, this could save you thousands of dollars. But there's one critical exception. Machine guns are not included in this law. Machine guns are still subject to the $200 tax and all NFA restrictions. And remember, you still can't make or buy new machine guns. The Hughes Amendment from 1986 still bans civilian ownership of machine guns made after May 19, 1986. The NFA tax repeal does not change that. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down the exact step-by-step process for buying your first suppressor under the new tax-free system and the biggest mistakes that delay ATF approval by months. Subscribe right now so you don't miss it. Change number 3. In May 2025, the ATF eliminated its zero tolerance policy. Here's the background. In 2021, under the Biden administration, the ATF adopted the Enhanced Regulatory Enforcement Policy, EREP. Gun dealers called it the Zero Tolerance Policy. Under this policy, ATF inspectors would conduct compliance inspections at gun stores. If they found any willful violations of federal firearms laws, even minor paperwork errors, they would recommend license revocation. No warnings, no corrective action. Revoke the license. Gun store owners lost their livelihoods over mistakes like transposing a number on a 4473 form or failing to properly record a serial number. These weren't intentional crimes, these were clerical errors. But under zero tolerance, any willful violation resulted in revocation. Hundreds of FFLs lost their licenses. In February 2025, President Trump signed an executive order directing the ATF to review all Biden-era policies. In May 2025, the ATF scrapped zero tolerance. The new policy is called the Administrative Action Policy. It provides a fair framework for addressing violations, particularly when those violations do not impact public safety. Minor paperwork errors now result in warnings or corrective action, not automatic revocation. And FFLs who had their licenses revoked under zero tolerance can reapply. The ATF will review those applications under the new standard. This is a major win for gun dealers, but policies can change with administrations. Document everything. Keep meticulous records. Don't assume the new policy will last forever. Change number 4. In October 2025, a federal court in Alabama permanently enjoined the ATF from enforcing its engaged in business rule against NRA members. Here's what that means. In 2024, the ATF issued a final rule expanding the definition of who is engaged in the business of dealing in firearms. The rule said even occasional private sales could trigger the requirement to get a federal firearms license. The ATF created a vague multi-factor test. How many guns did you sell? How frequently? Did you advertise? Did you buy with intent to resell? Did you make a profit? The problem was nobody knew where the line was. 3 guns? 5 guns? 10 guns? People were afraid to sell guns from their personal collections because they didn't know if they'd be violating federal law. The NRA sued in Butler v. ATF. In October 2025, a federal district court in Alabama ruled the ATF exceeded its statutory authority. The court permanently enjoined the ATF and DOJ from enforcing the rule against NRA members. This is significant, but limited. The injunction only applies to NRA members. If you're not an NRA member, technically the rule could still be enforced against you. In practice, the ATF is not aggressively enforcing the rule right now, but if you want to be covered by the injunction, join the NRA. The case is Butler versus ATF. The injunction is real, and it protects NRA members from this vague, overreaching rule. Change number 5. On February 7th, 2025, President Trump signed an executive order titled Protecting Second Amendment Rights. This is the first executive order in American history specifically focused on expanding gun rights rather than restricting them. The order directs Attorney General Pam Bondi to review every gun regulation, every ATF rule, every DOJ policy from the Biden administration, and recommend how to eliminate or modify them. The deadline was 30 days. The order specifically targets reports from the White House Office of Gun Violence Prevention, all DOJ and ATF rules on firearms, the government's litigation positions in Second Amendment cases, and ATF's firearm and ammunition classifications. As a direct result of this order, the zero tolerance policy was eliminated. The Office of Gun Violence Prevention was shut down, and the DOJ created a Second Amendment rights section. The executive order set the tone for the Trump administration's approach to gun policy. Roll back restrictions, defend gun rights, treat the Second Amendment as a civil right. But executive orders can be reversed by the next president. If a Democrat wins in 2028, everything Trump is doing could be undone. That's why legislative changes like H.R. 1 are more permanent. Change number 6. This is historic. For the first time in American history, the Department of Justice has a dedicated office focused on protecting Second Amendment rights as civil rights. The office is led by Harmeet Dillon. The mission is to investigate state and local governments that violate citizens' gun rights through restrictive permitting schemes, excessive fees, slow walking approvals, or outright denials. After Bruin, states like New York, California, and New Jersey passed Bruin response laws. These laws technically comply with Bruin by switching to shall issue permits, but they create massive new restrictions. Expanded sensitive places, onerous training requirements, high fees, social media checks. The new DOJ section can investigate those jurisdictions and sue them. This is the federal government actively defending gun rights, not just passively allowing states to regulate. But again, this office exists because of Trump's executive order. A future administration could shut it down. Hey, quick reminder. 73% of people watching this video right now are not subscribed. That means you're going to miss the next major gun law change or Supreme Court ruling. Don't be in that group. Over 50,000 gun owners rely on this channel for accurate, up-to-date information. Click subscribe right now. Change number 7. In May 2025, the ATF expanded Brady alternatives. Under the Brady Act, when you buy a gun from a licensed dealer, you have to pass a NEX background check. But there's an exception. If you have a valid state-issued concealed carry permit, you can use that permit instead of NICS. It's called a Brady alternative. In May 2025, the ATF expanded the list of state permits that qualify. More permits now qualify. Fewer NICS checks are conducted. This speeds up gun purchases for people with permits. Critics argue some states don't conduct thorough background checks when issuing permits. But for gun owners, this is a win. If you have a concealed carry permit, check if your state's permit is now a Brady alternative. You might be able to skip the NICS check. Change number 8. On March 26, 2025, the Supreme Court upheld the ATF's ghost gun rule in Bondi versus Vanderstock. This is the one loss on the list. In 2022, the ATF issued a rule redefining what counts as a firearm to include unfinished frames and receivers, called 80% receivers, and certain parts kits. Before this rule, you could buy an 80% lower receiver for an AR-15, finish it at home, and you didn't need a serial number or background check. The ATF's rule said 80% receivers that can readily be converted into finished receivers are firearms. Weapon parts kits that can readily be assembled are firearms. That means they require serial numbers and background checks. Gun rights groups challenged the rule all the way to the Supreme Court, and the Supreme Court upheld it, 7-2. The court said the ATF did not exceed its authority. Parts kits like Polymer 80 kits that come with jigs, drill bits, and instructions can be classified as firearms because they can readily be converted. This is a loss for gun owners, but the ruling is narrow. The court said kits that are clearly designed to be easily completed can be regulated. But the court left open the possibility that other unfinished receivers that are more incomplete might not qualify as firearms. The ATF now has authority to regulate some 80% receivers and some kits, but not all. It depends on how readily they can be converted. This creates uncertainty. If you want to build a gun from an unfinished receiver, make sure you understand whether that receiver is considered a firearm under the new rule. If it is, you need to buy it from an FFL and go through a background check. Change number 9. Constitutional carry has expanded to 29 states as of 2026. The most recent states to adopt permitless carry were Louisiana in July 2024 and South Carolina in March 2024. Constitutional carry means you can carry a concealed firearm without a permit if you're legally allowed to own a gun. 29 states now allow this. That's 58% of the United States. The full list includes Alabama, Alaska, Arizona, Arkansas, Florida, Georgia, Idaho, Indiana, Iowa, Kansas, Kentucky, Louisiana, Maine, Mississippi, Missouri, Montana, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Tennessee, Texas, Utah, Vermont, West Virginia, and Wyoming. But here's what you need to understand. Constitutional carry does not cross state lines. If you live in Texas and you carry without a permit, that's legal in Texas. But if you travel to Illinois, you cannot carry there without a valid permit that Illinois recognizes. Constitutional carry also doesn't exempt you from federal law. The Gun-Free School Zones Act still applies. You still can't carry on federal property without authorization. And constitutional carry doesn't affect reciprocity. If you want to carry in states that don't recognize permitless carry, you still need a permit. Many people in constitutional carry states still get permits for that reason. Reciprocity. A permit lets you carry in more states. Change number 10. On May 15th, 2025, the Supreme Court issued a unanimous 9-0 decision in Barnes v. Felix. This case changes how courts evaluate police use of force during traffic stops. The case involved a Texas constable who shot and killed a driver during a traffic stop. The driver, Ashton Barnes, was pulled over for unpaid toll violations. During the stop, Barnes started to drive away. The officer, Roberto Felix, jumped onto the car's door sill. The car was moving. Felix fired 2 shots. Barnes died. The legal question was, how do courts evaluate whether the officer's use of force was reasonable? The Fifth Circuit used something called the moment of threat doctrine. Under that doctrine, courts only look at the split second when the officer felt threatened. In this case, the 2 seconds Felix was on the door sill. Did he reasonably fear for his life in that moment? If yes, the shooting was justified. Everything before that moment didn't matter. But the Supreme Court unanimously rejected that approach. Justice Kagan wrote the opinion. She said, courts must look at the totality of the circumstances. That means everything. How the stop started, what the officer said and did, whether the officer had other options, whether the officer escalated the situation. All of it matters. This ruling affects gun owners because if a traffic stop goes bad and an officer uses force, the court will now look at your entire behavior. Did you follow commands? Did you keep your hands visible? Did you inform the officer you were armed? Did you make sudden movements? All of those actions are now part of the totality of the circumstances. But the ruling also scrutinizes the officer. Did the officer give clear commands? Did the officer try to de-escalate? Did the officer create the danger? This makes it a two-way street. Both your actions and the officer's actions will be evaluated. This is educational information only. It is not legal advice. Gun laws are complex and change frequently. Always consult a licensed attorney for your specific situation. Now let me give you action steps for each of these 10 changes. For the pistol brace rule, if you own a pistol brace, you're good. It's legal. But keep documentation showing when you acquired it. The ATF could try to regulate braces again under future administration. But start researching the process now so you're ready to file on day one. For the zero tolerance policy, if you're a gun dealer and you lost your license under the old policy, contact the ATF about reapplying. You might get your license back. For the engaged in business rule, if you're making private gun sales, be careful. The rule is enjoined for NRA members. If you're not a member, join. And don't make so many sales that you look like a dealer. For the Trump executive order, support organizations fighting for gun rights. Your membership dues fund the litigation and lobbying that result in these policy changes. For the Second Amendment rights section at DOJ, if your state is violating your gun rights through slow permitting, high fees, or unconstitutional restrictions, document it. This could be the basis for a federal lawsuit. For Brady alternatives, check if your state's concealed carry permit qualifies. You might be able to skip the niceties check when buying guns. For the ghost gun rule, if you want to build guns from unfinished receivers, make sure you understand the new rule. Some receivers are now classified as firearms and require background checks. For constitutional carry, if you live in one of the 29 states, you can carry without a permit. But get a permit anyway for reciprocity. It lets you carry in more states. And for Barnes versus Felix, during any traffic stop, keep your hands visible. Follow commands exactly. Narrate your movements. Stay calm. Under the new totality of circumstances, standard, everything you do matters. All right, let's bring this home. In the last 18 months, 10 major changes reshaped gun laws in America. The pistol brace rule is dead. The NFA tax is gone for most items. Zero tolerance is over. The engaged in business rule is enjoined. Trump's executive order is driving a rollback of Biden-era policies. The DOJ created a Second Amendment rights section. Brady alternatives expanded. But the ghost gun rule was upheld. Constitutional carry reached 29 states, and the Supreme Court changed how courts evaluate police use of force. Some of these are wins, some are losses, but all of them affect you. If you don't understand them, you could break the law without knowing it, or you could miss out on rights you didn't know you had. This information could literally change whether you stay legal or face federal charges. Subscribe now because I track every major gun law change, every court case, every new regulation, so you have the most accurate, up-to-date information. Hit that subscribe button. Share this video with any gun owner who needs to know about these changes. And I'll see you in the next one where we break down what to expect from the Supreme Court's decisions in Wolford and Hamani later this year. Legal disclaimer, this video is for educational and informational purposes only. It does not constitute legal advice. Gun laws vary by state and change frequently. Always verify current law and consult a licensed attorney for your specific situation. This video reflects information as of early 2026 and may not include the most recent developments